Okay, good morning, everyone. My name is Brad Gardner. Well, good morning, everyone. This is your first appearance before the Magistrate Court of Clayton County. My name is Brad Gardner, and I'm a judge in this court. I'm here to inform you of the charges that have been filed against you, to advise you of certain rights, to set bail on those offenses that I'm authorized to set bail, to schedule a preliminary hearing, and to determine whether you require the assistance of an attorney. You have the right to remain silent and say nothing, but should you give up this right, anything you say during this proceeding may be used against you. So please don't discuss the facts of your case. During this and all other proceedings, you have the following rights: to the presumption of innocence, to indictment by a grand jury for most felonies or by accusation for misdemeanors, to a speedy and public trial by jury, to see, hear, and question witnesses who are called to testify against you, to compel the attendance of witnesses to testify on your behalf, to testify on your own behalf or offer evidence in your own defense, and to have an attorney represent you. If you cannot afford an attorney, one can be appointed to represent you if you qualify. Some of you will be allowed to post unrestricted bonds for your release from jail. These bonds may be posted by cash, commercial, or property. Some of you will have special conditions on your bond that prohibit you from contacting certain people or going to certain places. You will also be prohibited from contacting the victim while you are in jail. If you violate the court's order, your bond will be revoked and you could remain in jail until your trial. You could also receive additional felony charges. It is important to note that if someone is listed as a victim in your case, that person will not be allowed to post your bond. Some of you are charged with offenses for which this court is not authorized by law to set bail. In this event, a bond hearing will be scheduled before a judge of the Superior Court of Clayton County, and you will be informed of that date. That's difficult for me to say. If you are currently on active probation, this court is not authorized to set bond at this time. Where the bond is appropriate in your case will be reconsidered after your probation officer has had an opportunity to consider this new arrest. The purpose of a preliminary hearing is to determine whether there is sufficient evidence to support the allegations against you. The standard at this stage is very low. A judge determining whether a charge goes forward at this stage only has to determine that it is possible that the crime occurred. Everyone has the ability to waive their right to a preliminary hearing. However, you should speak to a lawyer first if you are unsure about whether it is appropriate to waive your preliminary hearing. If you post bond, your preliminary hearing is automatically waived. You will receive notice at the address you give of your next court date. Lastly, would everyone please raise your right hand for me, please? Do you swear or affirm any statements you make during this proceeding shall be the truth, the whole truth, so help you God?
I do.
Okay, thank you. Let's start on the lady side with Miss Brogdon. Brogton.
Yeah, sir. Yeah, step on up.
Good morning, ma'am. You're charged with one count of obstructing an officer, which is a misdemeanor offense. Bond is going to be set at $2,000. You're also charged with one count of failing to stop or yield at a stop sign. Bond is set at $500. And finally, you're charged with reckless driving. Bond is set at $1,500. So you're going to have a total bond of $4,000. Your preliminary hearing date is going to be set for May 10th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll receive a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, sir.
Okay. Give me 1 second. Okay, ma'am, you do qualify for the appointment of lawyer. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
No, sir.
Okay, ma'am, you're free to go back.
Thank you.
You're welcome. Miss Davis?
Morning, Your Honor.
Good morning. Ms. Davis, you're charged with one count of aggravated assault with a deadly weapon and one count of aggravated battery. These are both felony offenses. I've set the bond at $15,000 for each offense for a total bond of $30,000. There's going to be a stay away provision on this bond, to stay away from a Shavanti Hiles. Do you understand that, ma'am?
Yes, sir. Yes, sir.
Your preliminary hearing date is going to be set for May 11th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you will receive a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, sir.
Okay, ma'am, you do qualify. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
Okay, one more question, sir. Did you
Yes,
say
ma'am.
how much the bond is?
The total bond is $30,000.
Mm-hmm.
Any other questions, ma'am?
No, sir. Thank you.
Okay,
Have a nice-
okay, ma'am. You're free to go back. Ms. Flynn?
How are you today?
I'm doing well. Ms. Flynn, you're charged with one count of simple battery. Bond is going to be set at $4,000. That's a misdemeanor offense. You're also charged with one count of criminal damage to property in the second degree. Bond's going to be set at $5,000. That's a felony offense. You're going to
Okay.
have I'm sorry,
I'm nothing. So altogether, my bond is what?
9,000.
Okay, thank you, sir. I appreciate the bond.
Oh, okay, ma'am. There's going to be a stay away provision on the bond to stay away from a Cedric Usher. Do you understand that?
Yes, sir.
Your preliminary hearing date is going to be set for May 11th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll receive a new court date in the mail. Do you want me to see if you qualify for the appointment of a lawyer?
Yes, sir. You can.
You do qualify, ma'am. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
No, yes, sir. If I could, I guess I'll ask them if I can use the phone to let somebody know that they can come bond me out now.
Yes.
To a bondsman, right?
I'm sorry, ma'am.
Can I go through a bondsman?
Yes, ma'am.
Okay, that's all. Thank you, sir.
Okay, you're free to go back.
Thank you.
Miss McGee?
Good morning, Your Honor.
Good morning, ma'am. You're charged with one count of driving under the influence of alcohol to the extent that you are a less safe driver. And actually, it says drugs, but on the front sheet, it says alcohol. The bond is this is a misdemeanor offense. The bond is going to be set at $5,000 for that offense. You're also charged with possession of marijuana less than an ounce. Bond is going to be set at $1,500. And you're finally charged with one count of an open container violation. Bond is going to be set at $500. So you're going to have a total bond set at $7,000. These are all misdemeanor offenses. So you're going to have a preliminary hearing date set for May 10th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll receive a new court date in the mail. You refuse to fill out the form. Does that mean you're going to hire your own lawyer?
I guess I would like to get my own legal counsel.
Okay. Do you have any questions of me, ma'am?
No, sir. No, Your Honor.
Okay. Okay, ma'am, you're free to go back.
Thank you.
You're welcome. Miss Sadler. Ms. Sadler, ma'am, you're charged with one count of criminal trespass. This is a misdemeanor offense. Bond is going to be set at $1,000. You're charged with actually two counts of simple battery on a police officer. Bond is going to be set at $5,000. Where did she go?
Oh, I was like writing it down.
Okay, I'm sorry. I was looking down and I looked up and I didn't see you anymore. So you can continue writing down what you need to write down. You're charged with 2 counts of simple battery on a police officer. These are also misdemeanor offenses. Bond is going to be set at $5,000 each. And finally, you're charged with 1 count of felony obstruction of a police officer. Bond is going to be set at $5,000. So you're going to have a total bond set at $16,000. Because the final offense is a felony offense, you're going to have a preliminary hearing date set for May 11th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll receive a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, you said my preliminary is May 11th.
Yes, ma'am.
What will happen during the preliminary?
So the preliminary hearing, another term for it is probable cause hearing. If you're still in custody at that time and you desire to have a hearing, you have a right to call witnesses and for the judge at that hearing to hear from both sides and for that judge to make an independent determination as to whether probable cause exists. But if you bond out, that hearing is automatically waived by operation of law, and the case gets transferred to the Superior Court of Clayton County, and it'll get assigned to a Superior Court judge, and then you will receive notices based upon that judge's calendar.
My bond is $16,000.
Yes, ma'am.
Oh, so I would have to pay $16,000.
Not the total amount. If you go through a bonding company charges you a fee, which is usually a percentage of the bond amount, and that's generally around 10 to 12% of the bond.
Oh,
And so just so you know, ma'am, I looked at your criminal history, and you have some similar incidents in your past, and then fighting with the police is never a good idea.
oh yeah.
Okay.
I know.
Okay, ma'am, you're free to go back.
Smith.
Ms. Smith,
Yes, sir. Good morning.
good morning. Ma'am, you're charged with 1 count of pointing a pistol or gun at another. Bond is going to be set at $5,000 for this offense. This is a misdemeanor offense, but there's going to be a stay away provision on this bond to stay away from a Bostic Lester. Do you understand that?
Yes.
Your preliminary hearing date is going to be set for May 10th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll receive a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, sir.
Okay. You do qualify, ma'am. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
No, sir, I don't.
Okay, ma'am, you are free to go back.
Thank you. Have a nice day.
You're welcome.
I have one more.
Okay.
Samir.
Okay, hold on one second. Is it Edie?
Yes, it'd be Edie.
Who are you representing here today, sir?
Samari Cora.
Okay.
I don't know.
McGee.
I got one. You got one.
Okay, we're gonna get to Mr. Cora in a minute. Did you say Samari King?
Samir King, Your Honor.
Okay, they have Samir King listed as a male on the WAA.
I'm trans, but I just don't have my bottom.
Oh, okay.
It's
So, is it okay for me to refer to you as Miss King or Mr. King?
Mr. King, please.
Okay. Mr. King, sir, you're charged with 1 count of criminal trespass. This is a misdemeanor offense. Bond is set at $3,000. You're also charged with 1 count of family violence battery. Bond is set at $5,000. You're charged with 1 count of aggravated assault. Bond is going to be set at $10,000. And I dismiss the kidnapping charge.
They didn't tell me I had, aggravated assault. They only said I had family violence and simple battery and, criminal trespass and kidnapping. That's all they told me. Where did the aggravated assault come in at?
Okay, so the document that I'm looking at has 4 charges on it: criminal trespass, battery, aggravated assault, and kidnapping.
Okay, criminal trespassing?
Yes, sir.
Trespassing.
And the criminal trespass is the allegation is that you kicked in a door, causing damage to a door frame that was worth approximately. Hold on, sir. Worth approximately $100. The battery charge is based upon the allegation that you punched this person, Danita Sotow, to the right side of her head, causing a large lump on the side of her eye and her ear to bleed. The aggravated assault charge is based upon the allegation that you pulled a knife on her. The kidnapping, it looks like they're saying that they, I guess, alleged the kidnapping is saying that you attempted to drag her out the door, but that's not kidnapping.
All we did was physically fight.
No, sir. Don't, sir. This is being recorded.
Oh, okay, I apologize.
Sir. At least have a chance to speak to your lawyer first before you start making statements about your case.
I apologize, sir.
No, I'm just saying, people say things all the time and get themselves in trouble. The lawyer comes in and the lawyer may have a great defense, but you've now on a recording made statements that works against your defense. So just wait and speak to your lawyer.
Yes, sir. I apologize.
Okay. No problem. So you're gonna have a total bond of $18,000. There's gonna be a stay away provision on this bond to stay away from a Danita Sotow. Do you understand that?
Yes, sir.
Your preliminary hearing date is going to be set for May 11th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll receive a new court date in the mail. Now, did you plan on hiring your own lawyer? Did you want me to appoint a lawyer to represent you?
Appoint one.
Are you currently working?
I work at All One Security, sir.
Approximately how much do you make per hour?
I make $15 an hour.
Okay, you do qualify for the appointment of lawyer. I'm going to appoint a lawyer to represent you. Now, is there any other questions you have that do not involve discussing the facts of your case?
No, sir.
Okay. All right, sir. You are free to go back.
Thank you.
Okay, we're gonna yes.
Before you move on, what was that defendant's name?
Last name was King, King. First name Samir, Samir.
Okay, so the warrants didn't print out. Can you give me the warrant numbers and the amount again?
Oh, yeah, I'm sorry. Because I had to do a whole different thing. So the criminal trespass printed out on the bond sheet.
Right, I got that one.
So 939 is battery, family violence.
Okay.
940 is aggravated assault.
Mm-hmm.
And 941 is kidnapping. And that's the one that I dismissed.
You dismissed. And what's the bond for 939?
5,000.
940?
10,000.
Okay. Thank you very much.
You're welcome. And I apologize. I meant, in the 2 times we spoke, I meant to tell you that, and it slipped my mind both times.
That's okay.
Okay. So, Miss Bermudez, are you ready to go? Or are you still in another courtroom?
Good morning, Judge. I'm ready to go.
Okay, let's bring up Mr. Morales. And he is a fugitive from justice. His warrant number is 2022 WA 06921.
Yes, sir. Thank you.
You're welcome. And after Mr. Morales, let's bring up Mr. Cora.
Yes, Your Honor.
Okay. Mr. Morales, sir, can you hear and understand the interpreter?
Señor Morales, ¿puede usted escuchar y entender a la intérprete? Yes.
Mr. Morales, you're here on what's called a fugitive from justice warrant.
Señor Morales, usted está acá en lo que se llama una orden de arresto por ser un fugitivo.
And what that simply means is that there's a warrant for your arrest out of another state, and in this instance, it's Colorado.
Lo que esto significa es que usted tiene una orden de arresto en otro estado y en este caso es el estado de Colorado.
And you're wanted on a failure to appear on an assault charge.
Y usted está siendo buscado por falta de comparecencia en un cargo de agresión corporal.
I'll start by saying that the Clayton County nor the state of Georgia has any interest in your guilt or innocence.
Voy a comenzar diciendo que ni el condado de Clayton ni el estado de Georgia tiene ningún interés en si usted es culpable o es inocente.
We're simply holding you because the state of Colorado has said that they intend to extradite you back to Colorado for this warrant.
Y nosotros solamente lo hemos estado reteniendo porque el estado de Colorado nos ha dicho que ellos lo están buscando con esta orden de arresto.
You have a right to challenge this process.
¿Usted tiene el derecho de desafiar este proceso?
If you want to challenge the process sometime between now and the next 90 days, there will be a hearing to determine whether you are the person named in the warrant and whether the warrant is valid.
Si usted quiere desafiar este proceso entre ahora y los próximos 90 días, va a haber una audiencia para determinar si usted es la persona nombrada en esta orden de arresto.
If at the
Yes,
end
it
of
is.
that, if at the end of that hearing, the judge determines that you are the person named in the warrant and that the warrant is valid, the judge will sign off on the state of Colorado coming to pick you up.
Si al final de esta audiencia el juez determina que usted es la persona nombrada en esta orden de arresto y que la orden de arresto es válida, entonces el juez firmaría la orden para usted ser enviado al estado de Colorado.
Correctamente.
At that-
And that'll be perfect.
At that point, the state of Colorado will have 30 days as a minimum to come and pick you up.
Y en ese momento el estado de Colorado tendría 30 días mínimos para venir a buscarlo.
They can request an additional 60 days, but that is not always guaranteed.
Ellos pueden pedir que le concedan 60 días adicionales, pero esto no siempre es garantizado.
Le voy a decir algo. A mí me dijeron que entre 10 días me iban a extraditar a Colorado.
Let me tell you something. They told me that within 10 days, I was going to be extradited to Colorado.
The statutory period is 30 days.
El tiempo por estatuto son 30 días.
I have not had any contact or communications with Colorado.
Yo no he tenido ningún tipo de contacto o comunicación con Colorado.
I do not know if Colorado has said that they're going to come and get you within 10 days or not.
Yo no sé si el estado de Colorado ha dicho que lo viene a buscar dentro de los próximos 10 días o no.
Tengo una pregunta. Dígale que si puedo pagar el bond aquí en Atlanta, Georgia.
I have a question. Can I pay the bond here in Atlanta, Georgia?
No.
No.
Ni en que se pueda pagar con dinero no se puede arreglar.
Even if I can pay, I cannot fix that with money.
So again, Clayton County in the state of Georgia has no interest in your case.
Una vez más, el condado de Clayton y el estado de Georgia no tienen ningún tipo de interés en su caso.
I do not know whether Colorado will accept payment or not.
Y yo no sé si Colorado va a aceptar pago o no.
If
Ok,
there is a payment to be made, it will have to be made in Colorado.
Si hay que hacer un pago, entonces este pago tendría que ser hecho en Colorado.
yo entiendo.
If you were to make that payment and Colorado contacts us to release you, you will be released.
Si usted hiciera este pago y el estado de Colorado se pone en contacto con nosotros y nos dice que los pongan en libertad, entonces nosotros los pondríamos en libertad.
Ok, está bien.
Okay, that's fine.
Está
So
bien.
for today's purposes, do you want to, I'm sorry, strike that. If you believe you are the person named in the warrant and you believe the warrant is valid, you can sign a waiver today.
Ok. Para el propósito del día de hoy, si usted cree que la persona nombrada en la orden de arresto y que la orden de arresto es válida, usted podría firmar el renunciamiento al proceso de extradición en el día de hoy.
If you were to sign the waiver, that 30-day period begins to run today.
Si usted firma el formulario de renunciamiento, los 30 días, el periodo de 30 días comenzarían en el día de hoy.
Ok, dígale que lo leo, firmar.
Okay, then I will sign it.
Okay, you will sign the waiver forms. They will send them to me. I will sign them and the clock will begin to run today.
Ok, entonces usted firmaría el documento de renuncia, ellos me lo enviarían a mí, yo lo firmaría y el reloj comenzaría a rodar en el día de hoy.
I encourage you to hire a lawyer in Colorado as soon as possible to address these charges.
Y yo lo exhorto a que usted se contrate un abogado en el estado de Colorado para lidiar con estos cargos.
Ok, está bien.
Ok, that's fine.
Okay, so once he signs the waiver, he will be free to go back.
Tan pronto él firme el documento de renuncia, se puede retirar.
Ok.
Ok.
Thank you, Ms. Bermudez. Have a good day.
You are welcome, Judge. You have a great weekend.
Okay. Let's bring up Mr. Cora.
Judge, just so I see that what his charges are. This would be what a bounder. Just wanted to let him know so that way when I do speak to him, I can understand what he has going. Correct?
I'm sorry, say that one more time.
I said I wanted to know, well, based on this, the charges, will it just be an automatic bound over to Superior so I can let him know that, or will we actually be entertaining the bond hearing today?
No, I can't set bond on this charge at first appearance.
I want to be. That's all.
And the reason I was confused is because it's only a bound over if you want to bind it over. You'll have to sign a waiver for it to be bound over.
And I got you.
But he is entitled to a preliminary hearing if that's what he wants.
I don't want to waive nothing. I would just get it over to the preliminary hearing.
Okay. Mr. Cora, you have taken advantage of the opportunity to hire a lawyer. So I'm going to speak about your case with your lawyer. You need to understand that there's nothing that's said here that's privileged or private. So don't say anything you wouldn't want the whole world to know. Do you understand that, sir?
Yes, sir.
Okay, so I assume and it's Edie or Eddie, I'm sorry.
Edie.
Edie. Mr. Edie, I'm going to assume that you've spoken to your client about these charges.
I've spoken with the family. I was just retained right when I received the link.
Okay, so and the reason I ask is that for some serious charges, I don't need to discuss it if I don't have to.
Yes.
So with these two charges, I cannot set bond on the first charge. So it's going to be denied pursuant to statute 1761. And the second charge, possession of a weapon during the commission of a crime, I'm gonna deny bond on that. He is entitled to a bond hearing and preliminary hearing. The preliminary hearing date is gonna be set for May 11th at 8:30 in the morning, courtroom 201. The bond hearing date is gonna have to be determined because it's gonna have to be before one of the elected Superior Court judges. And I don't know which one is gonna be presiding at the time.
And you said May 11th.
At 8:30 in the morning, and it's most likely it's gonna be by Zoom.
Yes.
Make sure
I'm
you
sorry.
file.
Can you give me his name and warrant numbers? It didn't print on my calendar.
Okay, I'm sorry. It's Cora, Kora.
Okay. So bond denied?
On 5-0, bond is denied pursuant to 1761. And on 5-1, bond is denied, just no bond denied.
I got it. Thank you.
You're welcome. So, Mr. Edie, do you have any questions of me?
No, I understand everything very clearly, and I'll be getting that information over to my client at the jail as soon as possible.
Okay, Mr. Core, stay in contact with your lawyer. You're free to go back, sir.
And this,
Attorney Edie, can you make sure you submit an entry of appearance so you can get all the notices?
yes,
And that is very important because it will normally, if there's an entry that hasn't been filed, it will automatically print the public defender's name. And
Understood.
so,
what would be the email? Do you just need me to mail it, or I mean, the normal way is mail it, but if you need one officially, I can send over one in the email as well.
Send it to me. I'm going to put my email in the chat for you.
No problem.
Judge Gardner,
yes,
before I log off, I have one more name, and I just want to make sure that I'm not needed.
okay.
I have Mr. Garcia, Alvin Garcia.
Does Mr. Garcia need the services of an interpreter?
No.
He says no.
Yes, sir. Thank you.
Okay, have a good weekend. Okay, are you Mr. Brantley?
Yes, sir.
Okay, Mr. Brantley, sir, you are charged with a number of serious felony offenses. You're charged first with committing the offense of burglary. And bond is going to be denied on that charge. You have 6 counts of violation of Georgia Controlled Substance Act and possession of controlled substance. Bond is going to be denied on those offenses. You're charged with 1 count of use or possession of drug-related objects. Bond is going to be set at $1,500. You're also charged with 1 count of possession of or transaction card fraud. Bond is going to be denied on that offense also. You have a preliminary hearing date set for May 11th at 8:30 in the morning, courtroom 201. You have a bond hearing date set for May 13th at 8:30 in the morning, courtroom 201. Would you like me to see if you qualify for the appointment of a lawyer?
Yes.
Are you currently working, sir?
No, sir.
You do qualify. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
No, sir.
Okay, you're free to go back. Mr. Brown. Mr. Brown, sir, you're charged with 1 count of obstructing or hindering an emergency vehicle. Bond is going to be set at $3,500 for that. You're also charged with 1 count of disorderly conduct. Bond is going to be set at $1,500 for a total bond of $5,000. You're going to have a preliminary hearing date set for May 10th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out and you'll receive a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
No, sir.
Okay, you're going to hire your own lawyer?
More likely, sir.
Okay, do you have any questions of me?
No, sir.
Okay, you're free to go back, Mr. Brown.
Thanks, sir.
You're welcome. Mr. Carter, Terrence Carter. Terrence Scott Carter, sorry.
Morning, Your Honor.
Good morning. You're Terrence Scott Carter?
Yes, Your Honor.
Okay, you're charged with 1 count of family violence battery. Bond is going to be set at $5,000. This is a misdemeanor offense. There's a stay away provision on this bond to stay away from a Sharon Carter. Do you understand that?
Yes, Your Honor.
Your preliminary hearing date is going to be set for May 10th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out and you'll receive a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, Your Honor.
Are you currently working?
Yes, Your Honor.
About how much do you make per hour?
$8.50, Your Honor.
Okay, you do qualify for the appointment of a lawyer. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
No, Your Honor.
Okay, you're free to go back.
Thank you.
Mr. Terrence Martell Carter.
Same exact name. Good morning.
Good morning, Mr. Terrence Martell Carter. Sir, you're charged with 1 count of aggravated assault with a deadly weapon. Bond is going to be set at $20,000. You're charged with 1 count of battery. Bond is going to be set at $5,000. And you're charged with 1 count of criminal trespass. Bond is going to be set at $3,000. So that's a total bond of $28,000. There's going to be a stay away provision on this bond to stay away from an Ernest Robinson. Do you understand that?
I do.
Your preliminary hearing date is going to be set for May 11th at 8:30 in the morning, courtroom 201. That date will get waived upon your ability to bond out. You didn't fill out, hold on, you didn't fill out the form. Does that mean you're going to hire your own lawyer?
Man, you can, I'm pretty much gonna have my own attorney, but you can sign me up for that though.
Okay. Let's walk back. Let's walk back through this. Do you want me to appoint you a lawyer? Yes or no?
I'm good. I just gotta get out and get a lawyer. I'm all right.
Okay. So, Mr. Carter, I'm gonna tell you, I've been a lawyer for 20 some years, and you get trained, and when you ask a question, you want an answer. And so when it's a yes, no answer, I'm good is not an answer.
No.
So yes or no?
No.
Okay. Do you understand the stay away provision?
Yes.
Do you have any questions of me?
No. Oh yeah, it was my bills in total, what, 28?
$28,000. Yes, sir.
Thank you.
Okay, you're free to go back.
Thank you.
Mr. Christian. Mr. Christian, sir, you're charged with looks like several misdemeanor offenses. The first is possession of less than an ounce of marijuana. Bond is going to be set at $1,500. The second charge is driving a vehicle without a license. Bond is set at $1,000. The third charge is driving a vehicle with defective headlights. Bond is set at $500. The fourth count is or charge is violation of seatbelt law. Bond is set at $500. Fifth count is driving on the wrong side of the road. Bond is also set at $500. Failing to dim headlights, bond is set at $500. And failing to obey officer, bond is set at $500. So let's see. Total bond of $5,000. Because these are all misdemeanors, your preliminary hearing date is set for May 10th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll receive a new court date in the mail. Do you want me to see if you qualify for the appointment of a lawyer?
Yes, sir.
Okay, you do qualify, Mr. Christian. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
No, sir.
Okay, you're free to go back. Mr. Coleman. Mr. Coleman, sir, you're charged with also a mix of driving and felony offenses. So driving a vehicle with no insurance, bond is set at $1,000. Driving on a suspended license, bond is set at $1,500. Says driving on a suspended registration, bond is set at $500. Obstructing an officer, bond is set at $2,000. You have 2 drug-related offenses ending in 9-2 and 9-3. Bond is going to be set at $10,000 for each offense. You're charged with 1 count of use or possession of drug-related objects. Bond is going to be set at $1,500. And finally, you have another drug offense ending in warrant number 9-5. Bond is going to be set at $10,000. So your total bond is going to be, let's see, $36,500. Because of the felony offenses, bond, your preliminary hearing date is going to be set for May 11th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll get a new court date in the mail. It looks like you intend to hire your own lawyer.
Yes.
Do you have any questions for me, Mr. Coleman?
No, sir.
Okay, you're free to go back. Mr. Coulter. I'm doing well. Mr. Coulter, sir, you're charged with 1 count of driving a vehicle on an expired registration. This is misdemeanor offense. Bond is set at $500. 1 count of driving a vehicle without a license. Bond is set at $1,000. 1 count of possession of marijuana less than an ounce. This is a misdemeanor. Bond is set at $1,500. And use or possession of drug-related objects, bond is also set at $1,500. So you're going to have a total bond of $4,500. Your preliminary hearing date is going to be set for May 10th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll receive a new court date in the mail. Do you want me to see if you qualify for the appointment of a lawyer?
Yes, yes.
How much do you make per hour?
I think 11 right now.
Okay, you do qualify, sir. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
Yeah, so listen, right, I take care of my mom, right? So would I be able to get like OR or something like that so I can get back home, OR?
No, sir.
All right, thank you. I appreciate you, sir.
Okay, you're free to go back. Mr. Brian Davis.
Morning.
Good morning, sir. You're charged with 1 count of following too closely. It's a misdemeanor, bond set at $500. 1 count of improper turn or improper signal. Bond is set at $500. That's also a misdemeanor. Driving under the influence of alcohol. This bond has been automatically set at $2,000, and reckless driving bond is set at $1,500. So your total bond is going to be set at $4,500. You're going to have a preliminary hearing date set for May 10th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll receive a new court date in the mail. Would you like for me to see if you qualify? Well, it says refuse, so you plan on hiring your own lawyer?
Correct.
I'm sorry?
That's correct.
Okay. Do you have any questions for me, Mr. Davis?
No.
Okay, sir, you're free to go back. Mr. Garcia?
Yes.
Sir, you're charged with 1 count of criminal trespass. I have dismissed that charge. You're charged with 1 count of family violence battery. Bond is going to be set at $5,000 for that charge. There's going to be a stay away provision on this bond to stay away from a Roseanne Peterson. Do you understand that, sir?
Yes, sir.
Your preliminary hearing date is going to be set for May 10th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you receive a new court date in the mail. You also refuse to fill out the form. Does that mean you're going to hire your own lawyer?
Yes.
Okay, do you have any questions for me, Mr. Garcia?
No, sir.
Okay, you're free to go back. Mr. Hillman?
Yes, sir.
Mr. Hillman, you're charged with one count of battery. This is a misdemeanor offense. Bond is going to be set at $5,000. One count of aggravated assault by strangulation. Bond is going to be set at $10,000. One count of cruelty to children in the third degree. Bond is going to be set at $3,000. So you have a total bond of $18,000. There's going to be a stay away provision on this bond to stay away from an Alexis Clintoria Hillman. Do you understand that?
Yes, can I ask you a question?
At the end. Your preliminary hearing date is going to be set for May 11th at 8:30 in the morning, courtroom 201, because the aggravated assault by strangulation is a felony offense. Do you want me to see if you qualify for the appointment of a lawyer?
Yes.
You do qualify, sir. I'm going to appoint a lawyer to represent you. Now, I cut you off. What was going to be your question?
You said I got to stay away offense.
I'm sorry.
You said I have a stay away?
Yes, you have to stay away from Miss Hillman.
All right.
Do you understand that?
Yes, sir.
Okay. Do you have any other questions?
No, sir.
Okay, you're free to go back. Mr. Jackson?
Yes.
Jackson not here. Jackson not here. You're not here. Jackson not here.
Kevin Jackson?
Not here. You're not here, man. Sir.
He's on the
He walked out.
call. I'm sorry.
He walked out.
Can someone come on the camera, please?
No, you need.
Sir, Your Honor, Jackson just walked out.
Mr. Jackson just walked out.
Yes, sir. I guess he refused to.
We'll go with Mr. Jules next, Your Honor.
He said-
Okay. Okay. He's gonna have to appear because there's a stay away provision on his bond, so he's gonna have to be told that directly. If he wants to sit in jail, he can sit in jail, I guess.
Yeah, you also. He also said move on to the next person out here.
Mr. Jules,
Jackson. Jackson. There you go. Jackson. Jackson right here. Hold on. Take a seat.
tell me your name, sir.
Mr. Jules, Bradley Jules.
Okay, Mr. Jules, sir, you're charged with one count of aggravated assault. That's a felony offense. Bond is going to be denied pursuant to 1761. You're charged with possession of a firearm during the commission of a crime. Bond is going to be denied on that charge. You're charged with possession of a firearm by a convicted felon. Bond is going to be denied on that charge. There's going to be a stay away provision on this bond to stay away from a Donovan Houseworth. Do you understand that?
Understand.
Okay. Your preliminary hearing date is going to be set for May 11th at 8:30 in the morning, courtroom 201.
So
You're going to have a bond hearing date set for May 13th at 8:30 in the morning, courtroom 201. You refuse to fill out the form. Does that mean you're going to hire your own lawyer?
yes, sir.
Do you have any questions of me?
No, sir.
Okay, you're free to go back.
Say May 13, bond hearing.
Yes, sir.
Thank you.
You're welcome.
Your Honor, Mr. Jackson's coming up.
This is Mr. Jackson.
Yes, Your Honor.
Mr. Jackson, sir, you're charged with one count of criminal trespass, damage to property. This is a misdemeanor offense. Bond is going to be set at $3,000. There's going to be a stay away provision on this bond to stay away from Lakedria Jackson. Do you understand that?
Yes, sir.
Your preliminary hearing date is going to be set for May 10th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out and you'll receive a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, sir.
You do qualify, sir. I'm going to appoint a lawyer to represent you. Do you have any questions for me?
No, sir.
Okay, you're free to go back. Let's see. We did Mr. Core. Mr. McClendon.
Let's see.
Yes, sir.
So you're charged with 3 counts of violation of Georgia Controlled Substance Act. The first count ending in 8-0, bond is going to be set at $10,000. The second charge ending in warrant number 8-1, bond is going to be set at $5,000. And finally, the third charge with bond ending in 8-2, bond is going to be set at $5,000. So you're going to have a total bond of $20,000. There's going to be a preliminary hearing date set for May 11th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll receive a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
No, sir. I'm on.
Okay, do you have any questions of me?
Can you tell me my court date again?
May 11th, 8:30 in the morning, courtroom 201, but it most likely will be by Zoom. That date will get waived upon your bonding out, and your case will get transferred to Superior Court, and you will receive a notice in the mail. You're welcome. Let's see, Mr. McLemore. Good morning, Mr. McLemore. Sir, you're charged with 1 count of battery. Bond is going to be set at $5,000. You're also, that's a misdemeanor offense. You're also charged with 1 count of criminal trespass, also a misdemeanor. Bond is going to be set at $3,000. There's going to be a stay away provision on this bond, a stay away from a Brittany map. Do you understand that? I need to hear you, sir.
Yes, sir.
Your preliminary hearing date is going to be set for May 10th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you will receive a new court date in the mail. Would you like me to see if you qualify for the appointment of a lawyer?
Yeah.
Okay, you do qualify, sir. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
No, sir.
Okay, you're free to go back.
Oh, yes, I do. I got one question.
Yes, sir.
I'm on VOP too, right?
I see that there's an indication that you do have warrants for your arrest. So if you don't clear those up, once you bond out, you'll be sent to whatever jurisdiction has the warrants.
All right.
Okay, sir, you're free to go back. Mr. Is it Mong?
It's Mohan, Your Honor.
Monghe, sir, you're charged with 1 count of aggravated assault. Bond is going to be denied at this stage. There's going to be a stay away provision on this bond, a stay away from a Tyron Morris. Do you understand that?
Yes, sir.
Your preliminary hearing date is going to be set for May 11th at 8:30 in the morning, courtroom 201. You're going to also have a bond hearing date set for May 13th at 8:30 in the morning, courtroom 201. Do you want me to see if you qualify for the appointment of a lawyer?
Oh, yes, sir.
You do qualify, sir. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
No, sir.
Okay, you're free to go back. Mr. Reese.
How you doing, Your Honor? Good
I'm
morning.
doing well. Mr. Reese, sir, you're charged with 1 count of battery.
Yes, sir.
Bond is going to be set at $5,000.
Why is the bond so high, sir?
I've set every bond at $5,000.
Oh, okay, okay.
I believe that adults have the ability to control where they place their hands.
I mean, I believe.
I don't talk about the facts of your case because this is being recorded.
I'm saying I'm innocent until proven guilty, so I know.
Yes.
So you're believing that adults should have a place to their hands. I agree too.
So the bond is placed upon whether the person did it or didn't do it, right? Because if I believed you did it, I'd be sentencing you right now. I
Right.
wouldn't be giving you a bond to get out. I wouldn't be giving you a lawyer to
I'm
defend you.
grateful. I'm grateful, Your Honor. Thank you so much.
Okay, so there's going to be a stay away provision on this bond to stay away from a Najla Kimball. Do you understand that?
Sir, yes, sir.
Your preliminary hearing date is going to be set for May 10th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out and you'll receive a new court
What
date.
date, sir? Pardon me.
May 10th, 8:30 in the morning, courtroom 201.
Okay. Do I have warrants, anything? Because I need to know if I bond out, man. No warrants?
Were you told that you had warrants?
No, sir, I shouldn't have no warrants or no holes or nothing.
So why are you asking me that?
Because I was asking, sir. Because I mean, in another county, Atlanta.
Okay, Mr. Reese, the only reason you would ask me that is if you had a good faith belief that
No,
you.
I mean, because it just, I know I work and there'd be a lot of stuff going on. And this was the first time I had a warrant. See, they had to come pick me up because I didn't know I have a warrant for this one. So.
Okay, hold on. I may be able to tell you.
I know up front they told me I didn't have no holes. And so, no holes and warrants, 2 different things.
So this is the only warrant that I see.
Thank you. God bless.
So, Mr. Reese, I'm just conveying information. I appreciate you thanking me, but I literally did not do anything.
You did a lot, little do you know. Thank you. Thank you.
Okay, so Mr. Reese, there is a stay away provision on this bond to stay away from a Najla Kimball. Do you understand that?
Sir, yes, sir.
Your preliminary hearing date is set for May 10th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out and you'll get a new court date in the mail. Do you want me to see if you qualify for the appointment of a lawyer?
Sir, yes, sir.
You do qualify, Mr. Reese. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
No, sir. Thank you for all your help.
Okay, you're welcome, sir. You're free to go back.
All right.
Mr. Rivers? Yes.
Never mind.
Mr. Rivers?
Sounds going wrong.
Mr. Rivers, sir, you're charged with 1 count of identity fraud. I've set bond at $20,000. This is a felony offense. You're going to have a preliminary hearing date set for May 11th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out and you'll receive a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, sir, you can.
Okay, you do qualify. I'm going to appoint a lawyer to represent you. Do you have any questions for me?
Yes, sir. Like, could you read like the grounds on charging me with this charge?
Okay, I will. Give me 1 second. Okay, it says that on May 1st, 2021 at 9151 Tower Boulevard Road, that's the jail, you committed the offense of identity fraud when using or possessing identifying information concerning a person against the state of Georgia, and that said defendant did knowingly, willfully, and lawfully, without authority or permission of the victim, Donta McCallan, use or possess a driver's license with intent to fraudulently use identifying information concerning said victim. Said accused did get arrested using the victim's information during their arrest, case number 21031813. So that's the basis. It says you got arrested and you used this name of Donta McCallan and got booked in under Donta McCallan, knowing that you were not Donta McCallan.
I don't recall telling anyone that information, so I was wondering, is there any way that you can lower my bond a little bit so I can at least make bond and try and handle this situation, please, sir?
Well, based upon this, I normally would not set the bond this high, but based upon the allegation contained in here, if this is true, you've now messed up this person's credit, their life. They could have, stop it. They could get stopped if there's a warrant in that person's name, and you're the person that's doing it.
Yes.
So
Yes, sir.
I take that very seriously.
Yes, Your Honor, and you should, you really should, but at the same time, I already have an ankle monitor on, Your Honor.
Well,
Like, is it anything you can do just to help me to resolve this situation?
The one thing I can say is that if you get arrested again, use your name. Don't bring somebody else into
I didn't use anyone.
your mess. Okay, well, that's the allegation against you. And that's why I set the bond the way that I said it.
But Your Honor, I'm just asking, can you have a little, any kind of leniency towards that, please?
No.
I don't want to sit in here for 30, 90 days waiting for a bond reduction.
Think about Mr. McCowan.
But Your Honor, it sounds like you're kind of biased because you already said that I'm guilty without even.
No. I set you a bond. Again, if I thought you were guilty, I'd be sentencing you right now. The bond is set on the alleged conduct. So I'll give you an example. People come here all the time from the West Coast with 20 pounds, 30 pounds of marijuana, and it's the first time that they got arrested. Statute says I can't set bond on anything over 10 pounds. And they sit there and beg, and I got a daughter, I take care of my sick mother, and can you do something? No, I can't, because the law says I can't do that. And in this particular instance, see, you are innocent until presumed guilty. The bond amount is based upon my calculation of what I think it is necessary for you to show back up in court at this stage.
Yes, sir.
And the fact that the allegation is that you use somebody else's identification upon being arrested, that causes me concern, which means I want to hear in a hearing everything so that I've appointed you a lawyer. Your lawyer can question the officer. Your lawyer can get the documentation. Your lawyer can show, as what you're saying, that, hey, I didn't do that, but I guarantee before this warrant was issued, they got the information, and that name sounds familiar to me. So you may have appeared before me under this name. So I'm not going to reduce this, Mr. Rivers.
But yeah, Your Honor, I'm asking you to just take into consideration when those charges was brought up upon me. You said May 1st. I was already incarcerated.
It was June 1st.
June 1st. Okay, well, I was already incarcerated. I think I did 10 months here last time I was here. And when I got out, one of the stipulations was that I had to get an ankle monitor. So I'm kind of out of money right now. I did everything I possibly can to get this situation how can I say it, straightened out the last time I was here, but nobody wanted to hear what I had to say, and I just had to find out.
Mr. Rivers, you have 14 cycles. Do you know what that means?
No, sir.
That means that you have interacted with the police 14 times. When you're here on June 1st, you're charged with hit and run and resulting serious injury or death, theft by receiving stolen property. And so the hit and run is that there's an accident and you left the scene.
Yes, sir. And all of those charges is why I have an ankle monitor. So you won't have to worry about me not coming to court. I'm just you can see how much I paid already. I'm just kind of strapped for cash, and I still have a family to take care of and everything. So I'm just asking you I don't mind paying the bond because I want to take it to trial and court and go through the processes and everything. But I'm just out of cash right now, sir.
So, Mr. Rivers, we can continue having this conversation, but I've told you I'm not going to reduce this bond.
Can you say 5,000, 10,000 out, sir? you're looking at my case right now. You see how much I paid. You see, I got this ankle monitor on already. Like, just please, sir.
Mr. Rivers, there's an easy way for you to not have those situations. To just do the right thing.
You're absolutely right. You're absolutely right. But the word is not perfect, sir. Like, we do things, and some like you might be more fortunate than me to be in a better mental state. I'm not saying that what I did was right or wrong, or I did it or I didn't do it, but I totally wanted to address the situation on it. And like, I just spent 10 months in here. I paid over $17,000 to get out the last time. I'm just coming to scrap, you know, and I'm right back in here for the same thing.
So it's actually not the same thing. It's based upon the same incident, but it's actually the separate charge.
I'm sorry, same incident. I'm sorry.
So why didn't you have your lawyer just combine all of this stuff and deal with it at the same time?
I was speaking with him about that. And he was saying that it wasn't really nothing he can do, because when we looked it up on the jail website, it was saying my name. So I was thinking everything was cool.
Well, I've given you my answer.
Please, Sean.
Mr. Rivers, I mean, you can sing me a song, but it's not going to change my mind. I see. This is a thing. When people's back is up against the wall, that's when they start wanting to pray to God.
No.
That's what you're doing right now.
No, it is not.
That's what you're doing. You said you were in here for what, 10 months?
Yes, sir.
Okay. When you went before the judge and you entered your guilty plea, you didn't say, hey, judge, look, this has been wearing on my heart. When I came in here, I used the name Dante McAllen, and that wasn't right, judge. And I just want to make certain that, judge, we deal with that right here and now, because that's the kind of person I am.
Well,
or did you believe that, well, hey, like you said, everything's cool, so I ain't got to worry about it?
But when I spoke to my attorney about it, we went to the Clayton County website and they had my name listed under it.
Well, the judge, you're on probation right now.
I'm on probation.
Okay, you can still go back for the judge and deal with this.
No, I'm asking you, you saying that I am on probation?
Yes.
Through who?
You said you have an ankle monitor on.
No,
what's the ankle monitor for?
That was for my bond. That was for my bond conditions.
So you haven't resolved the other case yet?
No, sir. That's what I'm saying.
So this still can get combined with that case.
Okay, and I just bonded out. I just bonded out from here like 2 months ago. That's what I'm trying to tell you. Like, all of this is like really one incident.
So let me advise you of what you may want to try to do. Speak to your lawyer about having this charge brought before the judge that you're now facing. Have that judge set a bond on this charge, and then you'll get out.
Yeah, that'll be
Mr. Rivers, this is not supposed to be easy for you.
I understand, right? I understand, Your Honor. I understand, but just put yourself in my shoes. Like, I know that's a bad statement to make, but like I just paid over $17,000 to get out of jail, cash. Like, not a percentage of that. I paid $17,000 plus the ankle monitor and all of this, and now I'm facing another couple $1,000s that I don't have, you know? And I don't want to like sit here for another 10 months. Like,
I just told you what to do.
Please, y'all, is any way you can drop it down 5 or 10,000, please? Your biggest concern is that I'm coming to court.
No. My biggest concern is that I've looked at your criminal history. I've looked at the allegations contained in this warrant, and I believe that as long as you can skate by, you're gonna skate by.
No, sir.
Well, then prove me wrong. If you can go talk to your lawyer, get this case transferred to the judge that's hearing the case, and get that judge to set you a bond.
And how long do you think that'll take?
It could be today. It could be Monday. It depending on what the lawyer is doing. But this is the thing that I want you to understand, Mr. Rivers, is that from when I look at your criminal history, the only thing that's going to stop you from going down the path that I think you're going down is that it has to be made difficult for you.
No, sir. If you can look at my record before 21, it was absolutely none of these, no charges even close to that.
So how you get 12 cycles from 21 to 22? So you're telling me you had 12 interactions with the police in 1 year?
Yes, sir. Yes, sir. I lost my dad, my grandmother, my cousin, my child, and another one of my brothers, all in 1 year.
So what happened in 2017 when you were arrested in DeKalb County on a probation violation?
I wasn't on probation. If you look at it, it was non-processed.
Okay, what is this? 2017 in Cobb County.
Yes, they charged me with possession of a firearm by convicted felon. I wasn't a convicted felon, and all those charges got dropped as well.
And possession of marijuana.
Yeah, I pleaded guilty to that.
Okay.
But
so you have been getting into trouble before 2021.
But it's nothing serious like this matter right here. I mean, possession of marijuana, Your Honor.
Which is why I said you're gonna skate by. Whenever someone says that a crime is really not that bad, that person is gonna skate by.
No, sir. What I'm trying to get you to understand was that I was charged with the possession of a firearm by convicted felon. And how did it go?
And possession of marijuana less than an ounce.
Yeah, by convicted felon. So how did it go from that to
possession of marijuana less than an ounce is not connected to a convicted felon.
Okay, but the firearm was. But I'm just trying to get you to understand, like it's not like just reading it on paper. Of course, it's bad, but it's not that. Everybody makes mistakes, Your Honor. I'm just asking you to have a little leniency on me. It's not like
you when you make mistakes, you got to pay for it.
It's not like I'm making the same mistakes over and over, Your Honor. It would just I need some help.
All right, let's put Mr. Rivers to the side. We're gonna deal with Mr. Russell because Mr. Russell has to get out of here, Mr. Rivers. And I keep telling you I'm not gonna change your mind, but I'm gonna entertain you as long as you want to be entertained.
Excuse me, Your Honor. As soon as we're done with Mr. Russell, I had to escort him back to the infirmary.
Oh, okay. So, Mr. Rivers, you are free to go back. I'm not going to change my mind. And I told you to contact your lawyer, get this case transferred to the judge that's ultimately hearing your other matters, and that judge will be in the best position to set a bond. Okay? All right, Mr. Rivers can be released. All right, thank you. Okay, Mr. Rivers, sir, you're charged with, I'm sorry, Mr. Russell, sir, you're charged with 1 count of theft by taking as a misdemeanor offense. Bond is going to be set at $2,000. 1 count of driving a vehicle after you change your address or not change your license, your address on your license after being at a location for more than 30 days. Bond is set at $500. And hit and run accident bond set at $1,500. You're going to have a total bond set at $4,000. These are all misdemeanor offenses, so you're going to have a preliminary hearing date set for May 10th at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll receive a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, sir.
Are you currently working, Mr. Russell?
No, I just got out of school.
Okay. I'm going to find that you do qualify, sir. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
Sir.
Okay, you're free to go back. Now I understand Miss Kurt is ready.
Yes, Your Honor. Madison Bush.
So, yeah, that's fine.
We'll take this off now.
No, yeah, it don't matter.
Good, morning, Your Honor.
Good morning, ma'am. We actually just got into the afternoon.
Yes, sir. Good afternoon.
Okay, I need her camera to be on.
Hold on, let me try it.
Okay.
Camera's on, but still black. Oh, let me refresh
What's
the
the
page.
name of this person?
I'm sorry.
The name?
Peart. She's the person that was continued from yesterday.
Okay.
Okay, ma'am, this is your first appearance hearing before the Magistrate Court of Clayton County. My name is Brad Gardner. I'm a magistrate court judge here. I am here just to tell you what you're charged with, to give you court dates, and to appoint a lawyer to represent you if that's what you want.
No, sir, I would want to appease the court and represent myself. I'm a certified paralegal. And
Okay.
I also have an attorney on retainer in New York City, Michael H. Aspinall.
Okay. So if you're a certified paralegal, you understand you have the right to the presumption of innocence, the right to,
Yes, sir.
in this case, accusation for misdemeanors, right to a speedy and public trial by jury.
And I would like to ask for a speedy trial as well.
Okay. You have the right to see, hear, and question witnesses who are called against you. You have the right to compel the attendance of witnesses to testify on your behalf. You also have the right to testify on your own behalf. And in this instance, you've said that you want to represent yourself, which of course is your right. You're charged with one count of family violence, simple battery. Bond is going to be set at $4,000. There's going to be, hold on, ma'am. I'm going to let you ask me whatever questions you want to ask me at the end. There's going to be a stay away provision on this bond to stay away from a Jalen Blackman. Do you understand that? Your preliminary hearing date is going to be set for May 10th at 8:30 in the morning. We say courtroom 201, but most likely it'll be by Zoom. Now, once you bond out, your case will get automatically transferred to the state court, to whatever judge will be assigned to hear your case. And so that May 10th date will get waived once you bond out, and you'll receive a new court date in the mail. Now, what was your question, ma'am?
What my question was, sir, Your Honor, is that Jalen is my husband. We're legally married, but we didn't tell our family because they want a big celebration for us. We're both the last child. This family violence incident happened because my landlord I know, sir.
Now, Miss Pert, and the reason that we try to stop people from
I understand what you're saying. I won't say anything. What I was saying is that.
No, ma'am. Let me finish. This is being recorded, and so I know you want to represent yourself, and you haven't seen the evidence that the state may present against you. So if you're making statements, you may kind of box yourself in a corner before you even have an opportunity to see the evidence against you.
So I plead the fifth.
Okay.
Got it.
Okay.
What I was gonna say is I do have a follow-up on the April 29th pertaining to that case with Mr. Blackman. So if my court date was the next court date, May 10th would be waived. I was gonna say I prefer to just stay here till then, because I'm already gonna go into prenatal care after I prove I'm in my first trimester, and I really prefer, I feel like this is a safer place than outside right now, to be honest with you.
Okay.
And
that choice is yours to make, man.
Yeah, so you don't have to put a bond on my amount, but I will call my attorney while I'm in here to get the best advice, legal advice from him as well.
Well, because this is a misdemeanor offense, you're entitled to bond by law. So I would actually be violating the law if I don't put a bond on this.
I understand completely, Mr. Your Honor.
Okay. Is there anything else, ma'am?
No, but I was gonna ask, since I do have to bond out, what is the bond amount, including the tax, state, and federal taxes? So I can give that to my attorney, because I'm gonna need the whole amount. So should you send me $6,000 to bond out?
Okay, ma'am, I can't answer your question if you start talking every time I start trying to answer the question. So the sheriff's department is required to add fees to this bond amount, and I don't have the fee schedule, so they will be able to tell you the final number.
Got it. So I will bond out, sir, and I do request a speedy trial.
Okay. Is there anything else, ma'am?
No, sir, thank you very much, and you have a great day, Your Honor.
You're welcome. You're free to go back. Okay, I think that ends the calendar for today.
Yes, Your Honor.
Okay. All right, thank you.